SJC-11774, Commonwealth v. Kirk P. Camblin.
Oh, yes. Yeah, I think we'll keep this one.
Good morning. May it please the court, John Fennell for Kurt Camblin. To find that the breathalyzer was reliable below, the motion judge relied on a state opinion from the Supreme Court of New Jersey, State v. Chun. And one of the questions that the court asked for an amicus brief was whether this court whether it was proper to rely on State v. Chun. And fortunately, the Supreme Court of New Jersey told us in footnote 2, that their case could not be relied upon outside of New Jersey, where the ALCA test used different firmware. In New Jersey, the ALCA test used firmware 3.1, and in Massachusetts, the ALCA test uses firmware 3.23. They're different functions and routines run by the different firmware, effectively making them different devices and not allowing the New Jersey opinion to be relied on to show that the ALCA test is reliable here in New Jersey.
Counsel, this would be a lot easier for me if you had challenged it at the trial. Why didn't that happen?
Well, it was there was an objection and at trial, and
well, I know there was an objection, but there was no expert testimony presented to establish the points that you wanted the judge to make about the reliability of the device.
There was no testimony. The counsel did raise it later at sidebar on reliability, but it's right, she didn't present expert testimony. The reason for that is that it would really distract from the issue at trial, which is it's fundamental. But it would be confusing for the jury, and that's why that's why we have these gatekeeper motions and hearings on the reliability of a complicated device like the ALCA test. A Lanigan hearing on this would have taken much longer than the trial itself.
Well, you could have. What I'm referring to is your expert testimony that this particular machine can't possibly give you inaccurate results, so you shouldn't trust it. Why couldn't you do that in some kind of abbreviated form at the trial? It's not a Lanigan hearing at the trial.
Right. Well, but it would be it would be distracting for the jury. The counsel didn't have funds for an expert at the trial. I know that when the cases were joined, some of the experts who provided affidavits and were willing to testify at a Lanigan hearing were one to occur were donating their time. So I don't. She didn't get funds or have funds at trial for an expert. I don't know what was available, but that would have swamped if the reliability thing had kicked off at trial. It would have to be curtailed because it would have gone on much longer than this trial actually did.
So could you explain how it was that these cases were consolidated for the purposes of whether or not there was going to be a Lanigan hearing?
My understanding is that they were being the defense bar in Middlesex County. They kind of got together and started litigating these motions and hiring experts or knowing people who volunteered their time and started raising the issue, and it became known that there were going to be a lot of them, and then eventually the justice who oversees the
Chief Justice, it was Chief Justice Connolly.
Yes, that's right. Eventually consolidated them and under Justice Sullivan, and Justice Sullivan then ruled on the papers and didn't hold a hearing. And he denied a hearing based on the papers.
Now, Judge Sullivan, as I understand his opinion, relied only secondarily on the New Jersey case. His primary argument was the statute has basically said if it's in accord with the regulations, it's admissible, and therefore it's analogous to the testimony of QAs and STP cases. The legislature says it's admissible, therefore it's no longer the subject of Daubert-Lanigan as long as it's in accord with the regulations. Why is that not the case?
That's not the case for two reasons. First, even with the statute, it had the same language before, back in Neal, about that breathalyzer evidence is admissible and relevant in OUI trials. This court did evaluate the reliability of a breathalyzer in Neal for radio frequency interference.
But the statute was substantially changed between Neal and, I mean, what Judge Sullivan was looking at was a very different landscape statutorily.
There are these provisions to check for the reliability. Now, the second thing is that the statute says the breathalyzer needs to be an infrared device. It's an equivocal use of infrared device if this breathalyzer here is an infrared device. The infrared device part of the breathalyzer here doesn't control. And here's an example from an apocryphal physics test. A physics student is assigned to determine the height of a building using a barometer. This sophomore physics student climbs to the top of the building, ties the barometer to a tape measure, uses the tape measure to lower the barometer to the ground, and then reads off the tape measure the height of the building. Did the student use the barometer to determine the height of the building? No. It's similar here, what's going on with the infrared device, infrared part of the test to determine whether or not the breath test comes from an infrared device. The fuel cell part of the breathalyzer has veto power. It's necessary unless the fuel cell and the infrared device are in tight agreement, it's an invalid test.
Well, but
What's wrong with that?
yeah, what's wrong with that? I mean, if it's a valid test, it's going to be the infrared,
Right.
correct, I mean, sort of supported by the fuel cell that says so.
It's inscrutable which one is doing the work. They're agreeing here, and both the way this device is set up, neither the infrared part nor the fuel cell they're both susceptible to interfering substances, other alcohols and similar.
But that's a different issue, isn't it?
It is a different issue, but it goes to the part of the statute that was added to provide reliability. That was concerned with a certain type of breathalyzer that only used the infrared device and depended on a chopper wheel or some other filter to keep out the interference from other compounds which could frustrate a breath test. This device doesn't have it, and the testing regime implemented under the statute doesn't assess whether or not the breathalyzer is actually working right because it uses a different subroutine for a live breath test than it does for the simulations that are in the statute and the regulations to assess the reliability.
So the real problem is that the statute, or the regulations construing it, don't provide for adequate testing. They provide for testing, which you're basically saying doesn't do the job.
They provide for testing that does the job for the old kind of breathalyzers that were used. This is a new breathalyzer, and that old regime just doesn't work on this new breathalyzer.
So is a reliability or a Lanigan hearing the right way to go about challenging what are, in essence, statutory or regulatory issues?
In this case, it is, because this court has the legislature can't overwrite due process protections, and Bradway was mentioned with the qualified examiners. Bradway was not a challenge to the qualified examiners based on due process, and one of the things that the court in Bradway said that makes the qualified examiner testimony come in is that the qualified examiners are there for cross-examination. We can't cross-examine the breathalyzer. The kind of cross-examination that would occur about the breathalyzer that would help determine the reliability is what could have occurred at a Lanigan hearing had one been held. And we didn't have a Lanigan hearing, and the judge ended up ruling on the basis of an incomplete record, relying on a decision that was about a different breathalyzer because of the code, and also didn't address criticisms that were raised in this case that weren't raised in New Jersey. And even the Commonwealth acknowledged that a different criticism was raised here.
So help me, I'm trying to understand your argument. Is this particular Draeger-Elko test 7110 MK3C breathalyzer in accord with the regulations and with the statute? Does it comport with that?
No.
Okay, so one claim is that it does not comport with the regulations, and I gather a second claim is that even if it did, it does not comport with due process. Am I correct in that?
Yes, Your Honor.
Okay,
And it doesn't comport with the regulations because of this infrared fuel cell issue?
Yes, Your Honor, that's right.
But I had thought the regulations expressly provided for the possibility of a supplemental means to do it in order to ensure accuracy, and that's what the fuel cell seems to be. It's a fail-safe. It seems to be something that you would want to say if this differs. We have two methods. If the infrared does not comport with method 2, there is no breathalyzer result.
The statute only says infrared. The statute doesn't have this fuel cell, which the regulations added in I believe, 2010.
So you're saying it's ultra-virus? It's not, the regulations are incompatible with the statute?
And it comes down to complementary. Now, is this sort of a flying buttress on the great, well-supported infrared test that's going on? If that were the case, then maybe this would pass muster under the statute. But that's not the case here. It's not just a little add-on check to make sure everything is okay.
Well, how is it different from the chopper wheel that it replaced? It's the same thing, isn't it?
It's not, because the chopper wheel prevented the interfering infrared radiation from ever getting to the infrared detector. In this case, if there's interfering radiation, it's still picked up by the infrared detector, and then the fuel cell, if what the infrared detector its reading picks up is different than what the fuel cell picks up, the fuel cell is vetoing. And also, one of the things
I thought the fuel cell did the same thing that the chopper wheel did, which is prevent interference from some substance that would otherwise skew the results. So I don't understand what the difference is.
The fuel cell is providing its own reading of the alcohol level in the breath. And in the tests that were submitted to validate this breathalyzer, in the brief, I run through the numbers from the test done in Paris, where they were submitting both the infrared test result and the fuel cell test result, and then combining those numbers to get their valid test result. And that's the evidence that they're pointing to say this is a reliable breath test. They're combined.
Yeah. So I take it you're saying that for the infrared test to comport with the regulations, it has to rise or fall on its own merits. And here, it's being shored up by or being reviewed by a fuel cell determination, and that's different than the chopper wheels, because the chopper wheels simply eliminated certain interfering waves, but the infrared reading was then it would stand alone.
Yes, Your Honor, that's right. The infrared would stand alone in the old tests because the interfering radiation would be knocked out by the chopper wheel or some other kind of filter. That's not done here. We have two independent tests, In Massachusetts, they're telling us that only the infrared is reported, but that depends on whether or not the fuel cell vetoes it. In the test results to validate the breathalyzer with these various international agencies, both test results were reported and averaged to prove the reliability of the breathalyzer.
Can I ask a non-scientific question? Does this device appear on the National Highway Traffic Safety Administration's conforming products list for breath testing equipment?
Yes, it does, and they did not test the source code when reviewing the breathalyzer for when it goes on there. We know that
You're saying it should never have been on there, so you're challenging the determination by the national agency that oversees all of this.
I'm not challenging the determination. I'm saying that determination doesn't prove reliability, as we've learned in many product recalls, the Toyota recalls, they're subject
But
to
the statute, I mean, that's what the statute calls for, doesn't it?
It calls for that as one of the preconditions
Right,
to
so,
make it.
but, I mean, that's what the statute says. So if it's there, are we entitled to go behind that?
I'm not saying that that it being approved by the National Highways Transportation Safety Board is erroneous. I'm just going behind what their testing was to show that their testing doesn't give us the reliability that the Commonwealth is pointing to. The main reason that the statute doesn't apply isn't because I'm challenging these previous imprimaturs that the device has received, challenging it because it's not an infrared device under the statute.
Thank you.
Thank you.
Good morning, Mr. Chief Justice, Associate Justices. May it please the Court, Assistant District Attorney Jamie Michael Charles for Middlesex on behalf of the Commonwealth. The defendant would like you to believe that this is a very complicated appeal that involves uninitialized variables, buffer overflow errors, weighted algorithms, but the truth is far from that. This is actually a very simple appeal because the reliability of the source code that ties in with the firmware of the ALCO test, which is what I will refer to this device as today, is not the question before this test. The question for purposes of a Dauber-Lanigan analysis, assuming the defendant is even entitled to one, which I'll address separately, is whether the device can reliably and predictably prove the amount of alcohol in a breath sample, and that it has been proven to do at state, federal, and international levels consistently and repeatedly. I'll turn briefly to the infrared question, since this Court asked several questions, and
Well,
I do view that.
That's part, I mean,
As
yes,
a separate
it's yes, it's a reliability issue, but I think it's also a statutory
Correct,
issue.
which is, I do view that as separate from the Dauber-Lanigan, and so I will address it briefly. And I will preface this by saying that I am not an expert in science, and so I'm going to do my best to explain the developments in the device.
Can you also do this in the context of, you know, I know at some point, you know, we get to the statutory issue, which has to do with laying out the testing that's appropriate. But it's possible for a statute to say to lay out testing that would simply be, you know, almost even on its face inadequate.
I suppose that possibility exists.
Well, I mean, you could say, like, you know, you shake the box, you know, and that'll tell you whether it's reliable. I mean, just be silly, but that's what the legislature adopted. That's what the regulations. Is there a way of challenging that?
Of challenging the regulations?
Adequacy of the testing that is being done.
I mean, I can envision a variety of scenarios that would go beyond what was done here. I will note that New Jersey and the experts at the Commonwealth solicited in this case have all held that black box testing, which is the sort of testing that we're talking about, where you insert known samples of here ethanol into the machine and determine whether it can accurately read those measurements, is an appropriate way to test these sort of devices, and has sort of been the way that these devices have been tested nationally for decades. But just specifically with regards to the infrared, just to set the stage for your honors, the defendant has essentially just presented an affidavit from an expert who is an astronomer, who has no familiarity with breath testing, who has never interacted with a breathalyzer, never practiced in the criminal sphere, anything of that nature. The Commonwealth rebuts that with the expert testimony of Mr. Reiser, who is the vice president of Draeger and who has been designing infrared breath testing devices for over 30 years. Mr. Reiser testifies in his affidavit that his company was the first company to develop a chopper wheel for use in infrared breath testing devices. And he very clearly lays out what the advancements in the ALCO test are. Justice Hines, you were asking about the developments somewhat. My understanding is that the earlier versions of the ALCO test relied on what are called halogen bulbs, and that those were very highly weighted infrared sources. And the reason that first a chopper tuning fork and then a chopper wheel was implemented was because the source was so strong that it did not cool off quickly enough, such that you could obtain the alternating current necessary to measure the difference in energy between, say, an empty chamber and a chamber that contains the breath alcohol. What Mr. Reiser suggested in his affidavit is that Draeger developed or uncovered a new lower energy infrared source. And that source, because it was of a lower thermal mass, was able to sufficiently cool off quickly enough to negate the need for this chopper wheel to cut off the infrared source. And so he's essentially stating that because you have this lower thermal mass infrared source, you no longer have this cooling problem, which was the reason the chopper wheel was developed and implemented in the first place.
Well, I'll just pose the question and you say I need to finish. But I thought that the argument that Mr. Fennell was making was this isn't, because of the role of the fuel cell, this is not an infrared device such as is required.
I can address that as well. I do view that as a separate challenge, but the Commonwealth interpreted the arguments below and on appeal to be saying, on the one hand, the infrared source is unreliable because it doesn't use a chopper wheel, and separately, it violates the statute because of this fuel cell. As my brother alluded to, in 2010, the regulations, they were not recodified, they were sort of reorganized and clarified. If you look at the CMRs that are relevant to this appeal prior to 2010, they did not follow a linear fashion, they jumped around, and it was sort of confusing to tie different sections together. All the 2010 recodification did, and I think the subsequent decisions are in agreement about this, is it reorganized the existing sections in a linear fashion, and it clarified some of the language. And if you look at sections 501 CMR 205.4, that clearly says that a device must use infrared breath testing technology to report an arrestee's blood alcohol content, but that this requirement does not preclude the use of complementary technologies designed to ensure the accuracy of the results or used to detect interfering substances. And that is exactly what is happening here. And that's what Mr. Reiser avers in his affidavit, and that's what all of this testing has shown.
So the fuel cell is a complementary technology?
It's a separate independent test. So the fuel cell test does not occur until after the infrared test. The breath is blown into the infrared chamber, the infrared analysis occurs, and then a small portion of that, once that analysis completes, a small portion of the breath sample is extracted from that chamber into a separate chamber, and then the fuel cell test takes place.
But what is the, I'm sorry, what is the report that is made a report of? Is it of somehow
only the infrared, in Massachusetts, the only result that is ever reported is the result of the infrared test.
Which is, but Mr. Fennell says that the fuel cell can veto the infrared test.
Only in the sense that it has recognized interfering substances such that the test is not valid. It is exactly what is permitted in the CMRs, a complementary technology that is used to ensure accuracy and detect interfering substances. And these reports in these tests in Paris that my brother seeks to bemoan on appeal, he does not dispute Mr. Reiser's assertion in his affidavit anywhere that that organization tests at the most stringent level whether a device can detect and eliminate interfering substances. And this ALCO test is the only device to have met that organization's standards. It is the strongest, it is the most, I guess, the only device to have ever met or exceeded the standards of that organization in terms of eliminating interfering substances when assessing the alcohol in a person's breath.
So if
The fuel cell is different from what the infrared is. That's not a good test. if it's not reportable by the infrared channel or whatever you call the device where the breath goes, that result is not reported unless it's consistent with the fuel cell. Is that right? So there's no fuel cell trumping the infrared.
Fuel cell result is never reported, will never be reported in Massachusetts, and will never be the result that appears on any breathalyzer report in court.
Okay.
But it can, I assume, invalidate the infrared test, or at least raise serious questions about the validity of the infrared test.
In which case it will never be used, is that right?
Correct. In which the case the machine will register the result as interference or not valid, and the subject presumably will have to submit another breath sample to the machine. So in that regard, it is in complete compliance with the CMRs and what they permit.
Well, could the test that was invalidated by the fuel cell, if it were allowed to print out, could it ever be favorable to the defendant?
Well, I think that question sort of misses the mark, because if the
defendant, it doesn't.
If it's not clear of interfering substances, and it's not in tight agreement such that we can agree that it's an accurate test, it doesn't really matter whether it's favorable. We're searching for accuracy, not exonerating evidence. And I think that sort of ties in with these breathalyzer machines and challenges that we've seen with regards to testimonial and why we don't consider them testimonial. These machines have no agenda. They're not attempting to incriminate somebody. If a person's blood alcohol content is below the threshold, they're going to report it as below the threshold. It's not an arm of the prosecution. It's just a neutral test that we expect somebody subject to if they're suspected of operating under the influence of alcohol.
Yes, but I guess at least my follow-up question to that is, you said in Massachusetts the fuel cell report is not separately reported. Does that mean it's capable of being reported?
I honestly can't speak to that. I don't know if other states allow fuel cell tests.
Because it's conceivable, and then following up on Justice Mina's question, if it's separately reportable, it might be, I don't know, maybe it would generate a result that could be favorable to the defendant.
The Commonwealth's understanding and the affidavit of Mr. Reiser in the record appendix represents that this dual test method was implemented solely to ensure accuracy. So this device was an infrared testing. Previous iterations were infrared testing devices, and this separate fuel cell test was implemented solely for purposes of ensuring accuracy of the result.
Not to be a standalone test.
It was not added to the device so that it could be separately reported. That was not the intent. And at least that's the Commonwealth's understanding.
Is it, listening to you, is it your understanding that what the fuel cell does is kind of act as it's only going to be different from the infrared if it's reporting interference? Is that right?
That's the Commonwealth's understanding. According to Mr. Reiser's affidavit, he represents that the infrared test is, to the extent, and the Commonwealth does not concede that this ethanol specificity argument has any legs, because there's no requirement anywhere with regards to that. But to the extent that we typically look for ethanol in breath, the infrared test is as specific to ethanol as you could expect to be, given that it uses this 9.5 micron range, which is a new range at which it's tested at. I understand it. It took me a long time to understand. And that it eliminated this chopper wheel, which is subject to environmental interference at times. Say if you banged on the table when taking the test, that might interfere with the rotation of the wheel. So now we don't have that. But to the extent that it's not potentially entirely excluding interfering substances, this fuel cell helps to further ensure that those are being identified and the tests are being flagged and set aside if there is interference.
Well, what's the nature of the interference, and how can it affect the infrared reading?
I don't have the level of knowledge to speak to that at length, but I believe there are a variety of substances. Acetone, for example, mouth alcohol could interfere with the test, because obviously we're trying to measure deep lung air and not any substances that are in the area of the mouth when the person blows.
Could that result in a higher blood alcohol reading under the infrared test, or could it lower the infrared reading?
I can't speak to that. I'm not certain. All I know is that it could result in an inaccurate reading, which is what the device is designed to eliminate. You want to make sure that the result is accurate. If I could just turn briefly, since I see my time is running short, to the issue of whether there even needs to be a Dauber analysis. The Commonwealth would just note that, again, as this court recognized, both per Section 24K and the CMRs, this evidence is deemed relevant and admissible by statute. And again, as was noted, the Neal case, which is the only case in Massachusetts to even remotely appear to be assessing reliability of a breathalyzer, predates by several years this change in the law and the implementation of these CMRs. The New Jersey breathalyzer was it was basically a function of the state police. There were no CMRs in place. There was no documentation being provided in discovery. They lacked all of the protections and calibration tests that Massachusetts codified. And that, in large part, is why there was the necessity for this large appeal and all these findings of a special master. Massachusetts has had these safeguards in place since the early 1990s. And as a result of that, these devices are rightly presumed to be reliable. If you look at the testing performed by NHTSA...
But do you agree that there also has to be a due process overlay, that it has to conform with due process?
I would agree that it has to conform, but as this court noted, the defendant is not precluded from challenging the reliability of this evidence at trial. You can solicit expert testimony. You can question the officer in charge.
But isn't that always going to be a question there about whether or not it's going to overwhelm the trial itself? And that it seems to me that the device that was set up here was actually a very good one, which was to have one judge take into account all of the evidence that could be the subject of separate evidentiary hearings or the parts of these trials in district court, which would, be burdensome. And wouldn't it have just been from a practical point of view to do it all at once and get all of the experts in, litigate it, and have it just be established? Wouldn't that just be a better means?
I see my time is up. If you permit me to answer that question.
Yes, you may.
Thank you, Your Honor. Assuming such an analysis is appropriate, based on your question, the defendant is still not entitled to a hearing. There's no cases ever held that a hearing has to be held for an individual's due process rights under Dauber-Lanigan, which, by the way, is an evidentiary test, essentially, not a constitutional test.
Yeah, but if the answer of the judge is, you don't need a hearing because the legislature says this is okay, that's not answering the challenge.
But the judge didn't merely say you don't need a test because the legislature said that. He reached the merits. He said, assuming we reach the merits, I still find it's reliable. And there's a really good reason why he found that. First, you can look to the Chun decision, which analyzed the same breathalyzer machine, which has been qualified by...
But there's a question about whether it is the same one.
It is the same machine. It is the 710 MK3C.
But isn't the source code different?
There are subtle differences in the source code based on the state, but Brian Schaefer, who designed the source code for Draeger, who testified before the special master at a 10-day hearing on the source code, which the Commonwealth included in its addendum, said that the core routines of the code are the same in every state. And he specifically mentioned Massachusetts. There are subtle differences, but the core routines and the major functions that we're talking about that are being argued about are the same in all of these states. And the Chun court, by the way, there was overlap of experts too. Mr. Wisniewski, who would supposedly have testified at a hearing here in Massachusetts, Mr. Workman, who submitted affidavits in support, both of those experts testified in New Jersey. New Jersey found Mr. Wisniewski explicitly to be not credible, I will note for you. So we had very much the same overlap. They all used the Lint program, which New Jersey found was inappropriate for assessing whether there are these sorts of errors. They said we're not convinced that anything Lint would find really calls into the question the reliability. And then the last thing I apologize that I would just note is separate and apart from all of this source code nonsense, since the Commonwealth thinks it's really not relevant. If you look at NHTSA's testing, if you look at the periodic testing in Massachusetts, if you look at the interfering substance testing done by the OIML, the International Organization of Legal Metrology, all of these involve the use not just of pure ethanol solutions, but also interfering substances, human breath tests, or simulated human breath tests. So we've had all manner of testing, and this device has never been found to be unreliable or not in compliance. So really, it's what are we here for? The defendant can point to nothing that calls into question this device's ability to accurately report the alcohol concentration in an individual's breath.
So are you saying it's that this machine has been generally accepted in the industry?
Yeah, for decades, and has never been called into question, frankly.
This particular ALCA, whatever it is, has been around for decades?
Yes, if you look at the affidavit of Barbara O'Brien in the record appendage, she says that NHTSA has approved the Alcotest 710 MK3C for 20 years.
And the defendant says that it's a proprietary product not subjected to peer review.
And I don't see a problem with that. We wouldn't require Samsung to provide the source code for their cell phone. We don't require companies to disclose this proprietary information.
Reviewed?
I'm sorry?
This product has been peer reviewed?
I can't say. I'm not sure it has been. That's certainly not a prerequisite. Daubert is not an exhaustive
certainly been
case.
approved by certifying agencies.
It has absolutely
Yeah.
been approved. It has not been. The source code has not been reviewed. But again, I think that that's almost like a non sequitur. We're missing the point. The source code should not matter. And I'll leave you with this. The Chun court essentially said, and I'm paraphrasing, if this device can constantly and reliably test the amount of alcohol in someone's breath over time, what does it matter how it does that? Why do we care if there might be some errors in the code if the device can nonetheless pass all of these tests and consistently do what it has been doing, and that's test breath alcohol? And so I apologize for going so far over.
I've got one more question. If somebody is stopped today and is given a breathalyzer, are they given this breathalyzer?
No, they are not. We now have a new model, a more advanced model. I have no knowledge of that model, but this decision will only affect past cases because the 710 MK3C breathalyzer is no longer the breathalyzer in use in Massachusetts.
Thank you.
Thank you, Your Honors.